Well, hello and welcome to another Coffee with Dr. Childress here. Now, today I'm going to be talking about my role as a witness for the parents and children in the family courts. I've been in the family courts for 15 years and I pretty much know everything that's going on. I know all the players, I know what's happening. And um, initially, when I arrived here about 15 years ago, from outside, I have outside expertise in a number of domains. I immediately recognized the situation, the lack of competence, and the institutional failures that accounted for that. And the technical terms for that are institutional capture by the forensic custody evaluators of the mental health services in the family courts for an experimental approach that they were developing that has been a complete failure, and institutional betrayal. That's where the institutions fail to protect a vulnerable population for decades. That's created quite a bit of difficulty. Now, with this, the primary source of my uh, witness of the situation is through a defense I've offered to the California Board of Psychology regarding some complaints that were filed against me, or a complaint filed against me by doctors Burnett and Larandos, because I was highly critical of their parental alienation concept and the fact that they continue to maintain it, despite the fact that there is legitimate DSM-5 diagnoses for the pathology. There's multiple ways to describe it. There is zero need for a pseudoscientific new made-up pathology label and new made-up symptoms by a self-proclaimed group of experts. And so they filed board complaint against me because I'm harshly critical of them for their professional practices, ethical standards, and the consequences of what they do. And so this is my defense to that. And it's up on my website. I just submitted it last week. So this is in two locations on my website. So you'll see first there the Childress California BoP defense. That's the document. It's about 80 pages long. You can toss it in an AI. And basically, it's describing the institutional capture and institutional betrayal in the family courts and my duty to protect, as well as 1.05 obligations relative to the professional practices in the family courts. And then there's all the appendices kind of grouped together into three units, appendices 1 through 13, 14 through 21. And I want to call your attention to the three Claude analyses. The first analysis there, the Claude analysis of a legislative brief. The legislative brief was developed by a ChatGPT-5, and I used that for the stimulus with Claude. But basically, the first section there, part one, or parts 1 through 3 on that first document, has to do with orienting Claude to the family courts. And so we went through and talked about the situation in the family courts. So if you want to find out about what's happening to you as a parent, what's happened to you as a child, or if you're interested in the family court situation and want to find out what it is, I would recommend that first Appendix 22, the Claude analysis of the legislative brief. Now, if you want to learn about the Gardnerian PAS experts, Dr. Burnett and his contingent of self-proclaimed experts, that would be the second, Appendix 23, the parts 4 through 5. And in that, Claude and I discuss the PAS experts and their consequences for the children and families for the last 40 years. And then the third part, Appendix 24, is where I would really direct your attention. Even if you don't read anything else, I would say you want to orient yourself to the Appendix 24 Claude analysis. And that has to do, it starts with a class action. The Claude and I discuss that as a possibility. Claude thinks it's worth exploring. So does Gemini. So does ChatGPT. So I think there's reason for exploring it. I'm a psychologist. I'm not an attorney. But from a psychological perspective, the systemic failures, the institutional betrayal, institutional capture, failure to protect, all these sorts of issues relative to the 50 state licensing boards and the American Psychological Association. The other defendant would be the AFCC, and then all the individual custody evaluators. So that would be your group of defendants. But the big pockets on that would be or the deep pockets would be the 50 state licensing boards who failed to protect their citizens from a dangerous practice that's harmful to children, lacks scientific legal value. It's an experimental approach and this new quasi-judicial role and a new experimental assessment procedure without IRB review, without a risk-benefit analysis, without any protections for the public. There's just a variety of problems, and those are all documented up in the BoP defense. But then that's the opening discussion, but then extended that out a little bit with Claude about what's the obligation to the children and parents who for the last 40 years have gone through this system of abuse, psychological abuse. They were never diagnosed, never protected. The parents lost their children. The children lost their parents, had their life destroyed by untreated, undiagnosed child abuse. What do we do about that now? We don't just abandon them to the consequences of a failed mental health system, failed APA, failed licensing boards, failed AFCC, failed psychologists. But we have all these consequences in the abused now adult children who are struggling to kind of figure out where they are and what their life is like, and as well as the parents who have unresolved grief from the loss of their children for many years, potentially decades. And so that's what we discussed then. And the importance for institutional betrayal, it's vital that the institutions acknowledge what happened. That's so essential for the healing process of people who have been betrayed by the institutions that should have protected them. That it wasn't them, that their reality is correct, and their lives were distorted through no fault of their own, but through the institutional failures. So I would recommend looking at that Claude analysis, but all three of them are pretty eye-opening on that. Then the second location for that on my website is over on the media press information. Now, with the media press information, I also have a section on AI in the family courts, because I think that's some interesting media articles over there too. A clinical psychologist bringing AI to the family courts, assessing AI and all that sort of thing that I think is story relevant. And if the media comes on that vector, on that location, I'm going to expand them out into the family courts and the institutional betrayal that happened there. So any media getting over to me would be a good thing for the family courts. And so that's a little bit higher on the media press information, a little more timely in our socio-cultural context. However, far more important is the issues going on in the family courts. It's a major scandal that's brewing underneath the surface, and as soon as it opens up, there's going to be some interesting situations. I don't know what's going to happen. I've never seen anything like this before. So again, on this, I have the section for the family courts on institutional capture, institutional betrayal. My defense document, it's about 80 pages, explains it everything, explains what I've done, explains the non-response of the institutions, and explains the betrayal, the incompetence, that's captivated the family courts, and then all my appendices and the Claude appendix 2. Now, with the um, my defense to the California Board of Psychology, for the last 15 years, ever since I've come to the family courts, I've had a duty to protect. Okay. So the moment I hit here, I'm out of complex trauma. I was clinical director, 3 University Assessment Treatment Center for Kids in Foster Care. CPS was our primary referral source. So I come out of child abuse. Plus, I have early childhood and attachment stuff, and so I know I'm bringing knowledge with me. And the moment I hit the family courts, I recognized the child abuse, psychological child abuse by a narcissistic, borderline dark personality parent that wasn't getting diagnosed or treated. And so we've had active child abuse and active spousal abuse of the targeted parent, using the child as a weapon for the last 15 years that I've been in the family courts, and the last 40 years that the forensic psychologists have been conducting their experiment on human subjects without IRB approval, without a risk-benefit analysis, and without protections for a vulnerable population, which is extraordinarily bad, to be in violation of all 3 principles of the Belmont Report. Plus, they're in violation of 2.01, boundaries of competence, 2.04, bases for scientific and professional judgments, 9.01, bases for assessment, 3.04, avoiding harm. So I've got 4 ethical violations, plus all 3 principles of the Belmont Report, just right off the top for the forensic custody evaluators. So I had duty to protect obligations immediately back in 2012, in 2010, basically. As soon as I became familiar with what was happening here, and I looked in to see what's going on. Why isn't the mental health system responding to child abuse? The moment I understood why, I have duty to protect, for the children and for their parents. 2 separate duties, but they're interrelated. So I've been carrying a duty to protect for 15 years without a location to discharge it. And that's what my board defense points out. I sought to discharge it to the institutions, AFCC. I went and told them, APA, petition to the APA, 19,000 signatures, 0 response from the APA Ethics Committee. And the licensing boards are captured. And so they don't review custody evaluators, and they put the custody evaluators on the board reviewing other. And so that's the institutional capture. I couldn't get to the licensing boards. But this complaint by 2 of the self-proclaimed experts in parental alienation, this complaint against me has allowed me to directly notify the California Board of Psychology, and through them the licensing board system, about the institutional capture, institutional betrayal, the level of incompetence, 2.01, 2.04, 9.01, 3.04, unethical activity, violation of the Belmont Report. It's allowed me to notify them directly, which is what my defense did. So I discharged my duty to protect to the California Board of Psychology. So for the first time in 15 years, I don't have a duty to protect you people out there anymore. Okay, so now I can go away, and I've done everything I can possibly do. Okay, and if it's now kind of in your zone, that's why I would suggest the parents look into a class action on this. And I would suggest the licensing boards terminate forensic custody evaluations in the family courts, return clinical diagnostic assessments, start attending to the situation in the family courts, because it's pretty significantly dire for the last 40 years. So this is a statement from my defense document in which I formally discharged my duty to protect to the California Board of Psychology. So I just want to read this, and I'll end with this statement. So, from my defense to the California Board of Psychology, formal discharge of duty to protect. Through this defense to the allegations brought by Doctors Burnett and Lorandos, I am formally discharging my duty to protect the children and parents affected by these systemic failures to the California Board of Psychology as the appropriate regulatory authority, and through the board to the broader professional oversight system. This document serves as my formal notification required under Standard 3.04 avoiding harm and Standard 1.05 reporting ethical violations that children and parents in the family courts constitute a vulnerable population under the Belmont Report. They are being subjected to ongoing psychological abuse that remains undiagnosed and untreated. This abuse is enabled by ethical violations, standards 2.01, 2.04, 9.01, 3.04, committed by forensic custody evaluators and self-proclaimed experts in parental alienation. Institutional capture has disabled the protective mechanisms that should prevent this harm, and the absence of viable reporting avenues has left this vulnerable population without protection for 15 years. The board now holds this information and bears responsibility for determining the appropriate regulatory response. I'm done. Okay, I came into the courts 15 years ago. I have taken all the steps along the path that are required of me, and I've documented those in my defense document. All the steps I've taken of educating the public and notifying the AFCC, notifying the APA. And so with this, I've now discharged my duty to protect to the appropriate oversight agency, the licensing boards. That's who should oversee it. The APA is significantly problematic as well. They're negligent they've been negligent in their oversight roles relative to the professional practices of psychologists. And so, yeah, the APA is a problem. But with this, now I can move off to other things, and now we're going into the judgment phase, where the California Board of Psychology needs to decide what it's going to do with this complaint, and then what it's going to do about this information. And this is supported by the New York Blue Ribbon Commission on Forensic Custody Evaluations. In 2021, found them dangerous, quote unquote, dangerous, harmful to children, lack scientific and legal value, and they have voted 11-9 to entirely eliminate forensic custody evaluations from the family courts because they're dangerous and harmful to children. The question for the licensing boards is, why are you allowing this to happen? Why are you allowing a psychologist to conduct a dangerous practice on the people of your state without oversight, without a risk-benefit analysis, without special protections for this experimental approach of a quasi-judicial role for doctors that does not diagnose or treat, and a made-up new custody evaluation approach that's an experiment on human subjects without IRB? Why is the licensing board allowing that? So the next phase for me, I'm working with AI in the family courts, and so I'm going to be shifting over my practice over into more focused on AI and that, and I'm going to kind of nest into my second opinion role in the family courts. So right now, for you parents that are out there in the courts, you are not being offered a clinical diagnostic assessment. That's impossible for you to get because the forensic custody evaluators are withholding diagnostic assessments so that you are forced to use their forensic custody approach, which solves nothing. So it's pure financial exploitation, pure and simple. But in the meantime, you don't have a diagnosis of child abuse for your kids. You don't have the diagnosis of the delusional thought disorder or the factitious attachment pathology. So, or the diagnosis guides treatment. If you don't get the child abuse diagnosis, the treatment's going to be misaligned. So you do not have diagnosis or treatment services in the family courts because they're being withheld from you. So that's just a situation. I don't know what to do about that. Okay, I can diagnose, I can serve as a second opinion, I can consult on stuff, but they're not doing it. Okay, so there's nothing I can do to make the psychologist do their job, diagnosis and treatment, competence, ethics code. Nothing I can do about that. So I'm going to pull back in. I've exposed myself to enough dangers on your behalf. I'm going to pull back in to my AI and run documents through that. So if you get a custody evaluation, you can just put a Dr. Childress surcharge on it and bring it over to me, and I'll bring me on and I'll have it run through the Chat GPT-5 and my own consultation, and we'll take a look and correct the situation that they've done. Now, you still won't be able to find treatment. You still won't be able to get a diagnosis, but at least potentially you can correct the situation off of them, or mental health reports coming in. It would be another, from treatment providers or treatment notes, individual therapist notes. I can run those all through AI and emails and stuff like that. So I'm going to collapse my practice just into doing the second opinion on the services that you're receiving out there. As to how you go about getting diagnosis and treatment for the child abuse in your family, I don't know. Go talk to the people who are in charge of that. Okay. I would suggest you get media attention over here. Okay. I've given you two vectors. You can get media over here, either on the Dr. Childress using AI in the family courts, or the institutional capture and institutional betrayal of the licensing boards and APA and everybody for 40 years have been unable to diagnose or not willing to diagnose child abuse in the family courts. And Claude estimates that's up in the hundreds of thousands of cases of child abuse that have been ignored, misdiagnosed. I forget which AI said it was. Oh, but if that were to happen in any other domain where hundreds of thousands of cases of child abuse were just not addressed, that would be a national scandal. Well, guess what? It's a national scandal. And so we need to get attention on this. But in order to do that, when I came into the family courts, I was just a single lone psychologist, and I've got institutional capture. I've got the forensic custody evaluators holding the field, and I'm just a single person. And so it's taken me 15 years to reach that point. But I've reached that point because on a separate vector, I've got 6 licensing board complaints against 6 of the top forensic custody evaluators. And you can add them all. You bring them in. I'll look at their vita. Their vita will not show competence for attachment, will not show competence for delusional thought disorders. So there's your violation at 2.01. Next time I take another seminar from the AFCC, guess what? 2.04 is going to be activated because they're not going to apply the established knowledge. Grab a vita, take a look at it. 2.01s, if they don't know the knowledge, they can't apply the knowledge, and then it's going to be 9.01, 3.04. And so that's going to be just going on all the time at this point. The other vector for me is to start writing journal articles. And so now that I've got my defense, I'm just going to kind of process those out again into various journal articles for the ethics journals and things like that. And so those are 2 of my vectors, and then I'm going to be doing more on AI psychology and AI clinical psychology as AI comes in, because I think the AI is going to rock the world of the family courts. It's just going to change the dynamic everywhere when every mental health professional can have their vita reviewed by an AI and have their report reviewed for standard 2.04, and is it coherent and what's going on. I think getting a second opinion review from an AI is going to terrify the incompetent mental health people in the family courts. And guess what? They're all incompetent. So again, I don't know what's going to happen because I've never seen anything like this. But it's going to be a bit of a chaos for a little while and a bit of a ride. So if you, as parents, for your children, attorneys for the parents, or the courts, want the situation solved, if you want a treatment that fixes the problem, if you want to protect children from child abuse, then you're going to have to do something about that. Because I have done everything I can on your behalf. There's nothing more I can do. I've discharged my duty to protect. Okay, so now it's in your ballpark. Okay, I would suggest you get media attention over here first, and you get legislative attention, and start with the California legislature. You can start with any legislature that you are in, so Missouri or Indiana or North Carolina. Start with your legislators. Take the Claude stuff to them, get them attending to the situation with their licensing boards. You can hook them up with me. Okay, I'm more than willing to talk to any legislative aide or media representative that's available or interested. But it's not me that has a duty anymore. It's you. You're the parent. You're the one that's supposed to be protecting your children. It's the court that's supposed to parent patrie. They're supposed to be protecting the children. So if the court wants mental health services, a diagnosis and treatment for the child abuse, then the court's going to have to do something to ask mental psychology and say, hey, APA, why aren't you giving us a diagnostic assessment? Why are you giving us this low quality of mental health services for the courts when our decisions are so important? Okay, if you want a diagnosis and treatment and protect your children and get your life back to normal, then you have to go to the APA and find out why are they giving you such awful psychologists. You're going to have to go to the licensing boards and say, why aren't you enforcing ethical standards? Okay, that's up to you. Okay, I can't do that. I know what to do. I know how to fix it. I know what the pathology is. I know everything. But if there's no motivation out there, things are going to get fixed. Okay. And again, I put myself in danger. I've spent 15 years with this difficult pathology, being the only one that wants to fix it. And so I've discharged my duty to protect. So I'm kind of good to go at this point. So with that, I've described my witness function. And witness is a sacrament. Okay. It's an important moral activity in when there is immorality, when there's problems like this. It's unfortunate because it's to activate that sacrament of witness requires that the person walks the path of suffering. Okay, and that's what the parents and everybody out there has done, and I've witnessed it, and so that allows me to then document everything that you've been through. But unfortunately, you had to go through it, and that's why we can't abandon those who did, because I saw them. Okay, I know who they are, and we need to go back and recover them, to recover those children. We never abandon a child to child abuse, even if they're now an adult child. So with that, I'm going to run off to the rest of my day, and good luck to everybody out there.